by the courtroom.
Yes, Mr. Moles.
My Lord Justice Lewis asked if we had a copy of the directions. We've provided those. There was also a short ruling by the judge on the 23rd of July, which we've provided to the court as well. The directions in relation to evidence are at directions 6 and 7, including obviously evidence from a very abbreviated timetable from the usual judicial review norms for service of evidence by the defendant and then evidence in reply. And there is some reference in paragraph 4 of the ruling to the defendant being able to identify anticipated steps which would necessarily be a relevant part of any factual matrix for any judge considering the question of a mandatory order, even on the timetable being put forward by the claimant. I think that's a reference to the revised landfill gas risk assessment and management plan that were produced by the interested party, or by the second respondent, I think, towards the end of July of this year. Of course, what wasn't in anybody's mind at that time, that is to say on the 23rd of July, was the contents of any report published by Public Health England as regards acceptable levels, which came in the event the day before the date specified in direction number 5.
And there was a claim for interim relief, and what happened to the claim for interim relief then? It all started because there was an urgent application for interim relief within 24 hours.
Yes, that essentially, I think, was rolled up in the substantive hearing.
Right. So at what point did the application for interim and final mandatory relief get abandoned? Do we know?
The application for final mandatory relief was, Mr. Wise will tell me I've got this wrong, but my recollection is that he abandoned that in opening his case on the
18th of August.
Yes.
Okay. And the interim relief,
that I think
never just happened, just hung in the air.
Fell away, I think. Yes. Is that right? Yes, right. The Miss Lean, who was in the case then for the EA, she tells me that effectively there was a decision that the better course was to expedite the hearing.
Expedition rather than interim relief. Yeah.
That's paragraph 3 of the ruling that we've just handed up.
Yes. Thank you very much. Yeah.
Yeah.
Oh yes.
Anyway, that's all history now.
Yes. But it certainly gives you an indication of the pace at which the preparation of the evidence was proceeding.
If you're going to the directions, are you?
Yes, I can.
I was only noticing paragraph 6 of the directions, which required the defendant and interested parties by noon on the 6th of August.
Yes.
To file and serve detailed grounds for contesting the claim, together with any areas of disagreement with the evidence of Dr. Sinner or Dr. Salt.
Yes.
And so forth, and any written evidence or expert report that is to be relied upon. And that was the day, was it, when the new guidance emerged?
It was the previous day, the 5th.
Oh, the previous day, sorry.
Yes.
Previous day.
And then the timetable obviously then was written so as to allow the claimant to reply, and that's the subject matter of paragraph 7.
So there was a tight timetabling to
yes.
lead up to the rolled-up hearing.
Yes. And certainly, I mean, if the phrase "in the moment" is apt to describe this case in more ways than one.
Yes.
And which isn't an entirely facetious point on my part, because of course one shouldn't forget that the court was being asked to consider the performance of the regulatory process and its effectiveness, if you will, against the legal principles. At a time when, on any view, it was in progress, and it wasn't actually submitted. At least I don't recall it being submitted with any force. No. That we'd already reached the stage where we'd got beyond the point of no return. That there was a clear failure to deal with matters swiftly, giving rise to legal unlawfulness. But if that was submitted, then it was an argument that the judge plainly didn't accept. That is an important point of context in our submission to this case. Of course, the corollary to that is that the agency has continued its work. The interested party has continued to operate the site, and the local community has continued to keep the feet of those parties to the flame as best they can.
Yes. Well, the urgency of the whole matter and the reasons for its urgency are entirely clear. There's no dispute about any of that, and that's been accepted from the very outset.
Yes, yes.
It was clearly accepted by the parties before the judge, by the judge himself, and indeed now by this court.
That is, I entirely accept that, and indeed we've made the same point in the early paragraphs of our skeleton, the reasons for it. But it nevertheless is true to say, in my submission, that if this court is of the view that the judge has, in your lordship's phrase put to me, overstepped the mark, it doesn't follow from that at all that the agency is relieved from its obligations.
No. I mean, your argument is, be it right, be it wrong, your argument is that the Environment Agency is acutely conscious of its obligations, and those are continuing obligations, as it were, come what may.
Yes. Which stand, of course, in domestic law as much as, well, they stand in domestic law under the Human Rights Act, but they stand in domestic law in relation to its responsibilities as regulator. In any event, it has certain principles which it must apply with under the environmental protection legislation, which are touched upon in the judgment. They don't give rise to any particular issue before this court, but they are nevertheless there. They form part of that regulatory framework.
Sorry, looking at the interim relief, looking at page 250, that was actually mandatory order suspending the permit until the interested party could ensure that there was a separation of gypsum and biodegradable waste. So that's what the initial thing was, the suspension of the permit.
Yes.
If this is right at 250. We haven't got the urgent applications, which is the next thing I'll ask you to get overnight, I'm afraid.
I'm not sure there was there actually an application.
Yeah.
Well, I wonder whether there was in fact a formal application submitted. We'll check that for you. And yes,
because if it came before the immediate judge, there ought to have been a Form N 461 or whatever it is.
Yeah.
Yes.
Because Mr Justice Fordham says in his ruling that the matter first came before him when he was the immediate judge.
Yes.
So one would assume there was a form.
One would have thought there would have been. Yes. Well, we'll do some.
That'll tell us what the reasons for urgency are as well, you see. That's why it's quite useful to go back to the pleadings. I know it's old-fashioned again.
No, I'm.
Because the relief sought in the claim form was partly interim relief, which was an interim order requiring the defendant to suspend the interested party's permit until the interested party taken appropriate steps to stop letting gypsum-based stuff into the landfill. And then the final relief was a declaration that there'd been a breach, and mandatory relief requiring the defendant to take appropriate and adequate measures to remove the risk of claimant's health.
But if I can just assist and help my lady in the court, there was an urgent application, of course. Unfortunately, we don't have it in the papers, but we'll see. We'll get.
It'll
that.
be useful to piece together what
absolutely,
happened, especially the reason for urgency. Yeah.
Yes, yes.
Thank you very
We'll
much.
do that overnight, my lord.
Thank you very much, Mr. West.
Ms. Lean's just shown me what's said in section 1, reasons for urgency. That's in the N463. Yes. So yes, it was essentially to do with the urgent need to address the impact on the claimant. But we'll make sure we have copies of that for you. It's helpful, if I may, as we're at the claim form, to note, as I think my lady has, the claim was the relief sought was founded upon an allegation of a current breach, and indeed the way in which it was put in section 3, which is where one gives details of the decision to be judicially reviewed, page 211, was an ongoing failure to comply with the positive obligation. So it was being said at the date when the claim was filed, the agency is in breach.
Well, 3.2, 7th of July onwards.
Yes. And that the nature of the breach was identified in the Statement of Facts and Grounds. There were 3 grounds. The first was is stated is to be found at page 238. The claim was rooted in section 6 of the Human Rights Act, paragraph 48. The positive obligation arising under Article 2 ECHR was identified in paragraph 51. And then at paragraph 60, on page 241, that obligation, as it applied to the present facts, is set out, paragraph 60. And then the breach of that obligation is identified at paragraph 61 on page 242. And the breach is essentially that there's been a failure to take measures within the scope of the agency's regulatory powers, focusing in particular on the adequacy of the enforcement notice, and at 61.4 on page 243, a failure to take further steps. So the nub of the asserted claim was an omission, failure to act in the exercise of its powers. Ground 2 essentially repeated the same complaint under the aegis of Article 8, paragraph 63 on page 244. The application of Article 8 to the present case and the fact that and the argument that a positive obligation had arisen is at page 74. Paragraph 74, page 247. And then the alleged breach is at paragraph 75 and particularised over the page. And then there was a third ground founded on the same side duty at common law. And the defence to those grounds, which was set out in the detailed grounds of defence we looked at briefly earlier, that's at tab 14, beginning at page 140. The defence to ground 1 in Article 2 begins at paragraph 38 on page 151, and the submissions are at page 155. The first argument at 51 was that Article 2 wasn't engaged because the risk to Matthew was not immediate, and that therefore Article 2 wasn't engaged on that basis. But 52 went on to consider the position if that argument is to fail.
But you're not running 51 now, you accept
No,
there is a real and immediate risk to the child's life.
Exactly.
Yeah.
And then 52 onwards dealt with that's the position that we now accept in the alternative. And essentially, issue was joined with the assertion that the agency had failed unlawfully to exercise its powers in order to take effective steps in this case to address the issue of excessive hydrogen sulphide emissions from the site. And as you can see, an invocation of 54 pointed to the fact that it wasn't no particulars were given of any further steps that might be taken. An answer was given to why revocation and suspension, etc., would not be effective in this case. Reliance was placed upon authority, and reference was made to the provision of information in paragraph 58 and the importance of that, and how the community had been kept informed in this case. And then Article Ground 2, the response to that, first of all laying out the case law, and you see at 63 a reference to Fadieva, and then 66 essentially repeating the defence to Ground 1, and then the Ground 3 was addressed in the final paragraphs. So the issue on the pleadings was fair and square, a breach, current breach of the Human Rights Act, Section 6 to 8, by reason of a violation of the claimant's rights under Article 2 and Article 8 of the Convention. The judge said that the third ground added nothing of substance to the issues raised under those two grounds, and there's no suggestion before this court that the judge was wrong to take that view.
Well, he also found that there'd been compliance with the Tameside duty because you'd taken advice. That's right.
Yes. I'm being too reticent. Yes. So the focus was on what had happened rather than what was to happen. What was to happen hove into view essentially and primarily because of the supervening presence before the court on the 18th of August of the production by Dr. Coetzee, his evidence of NC4, of the recently published up-to-date risk assessment report by Public Health England. But it formed no part of my learned friend's case to say that there were things that the agency, to look forward. His case was that the agency is already...
They couldn't have been in the claim form because it came before the thing. I haven't looked back at the claimant skeleton with that in down. Does the claimant skeleton refer to NC4?
Not that I can recall, and certainly not to indicate that, if you will, a further and freestanding ground is now being advanced on the basis of NC4. The way in which the issue that the judge ventilated deals with in paragraph 63 of the judgment, which is his flight path, as it were, is the need for a plan. It was the judge who raised that analysis in the course of argument, and it was and my understanding was that it was NC4 that really raised that that triggered that in the judge's in the questions that the judge posed to the parties. And so that's all of a piece with, if you will, the judge is saying, whatever may be the issues raised for me to determine on the basis of the pleaded claim, I think there's a need here for me to roll up my sleeves and give some advice as to what should happen hereafter. Certainly consistent with that, and it's consistent with what he said. We looked at this earlier, but what he said in paragraph 50. You remember the bottom of the page. We looked at this just before, short adjournment. The logic of the Strasbourg Court's decisions. This is page 121. The logic of the Strasbourg Court's decisions and analysis in these cases would, in my judgment, involve the National Human Rights Court enforcing an HRA Section 6 type obligation, asking itself in the moment whether there is an identifiable content to an applicable positive operational duty. If so, give such remedies as ensure that the duty is being complied with. Clarity, etc. But there's nothing in the Strasbourg case law that I've shown this court. There maybe I've missed something that Mr. Wise will draw to your attention. But there's nothing in the Strasbourg case that I've shown you that supports that approach. Nothing in Fadieva, others, that says the task of in order to give an effective remedy, if you like, under Article 13 in convention terms, in cases such as this, one has to identify the content of a positive operational duty and give a remedy to ensure that that duty, as so identified, is complied with. And of course, in domestic terms, the position is clearly stated by Parliament in the Human Rights Act. Section 6 to 8 of the Human Rights Act tell the court that they set out the role of the court and the nature of the remedies that the court should give, and in what circumstances, where there is an allegation that rights under convention rights have been violated.
Right. Acts incompatibly, has acted or proposes to act.
Yes.
But even in addition, it's not limited. One could still have an advisory declaration if the circumstances were appropriate as to the content of the convention, couldn't one?
Well, it's not my case to say no. That can never be done, because I can't point to any authority that says that it is in principle inappropriate to do that, and that there is learning and also commentary that draws attention to the breadth of the court's power. But what I do submit is that the starting point for analysis in order to understand a principled approach surely must begin with what the Human Rights Act says, because this is a Human Rights Act claim. It always has been. And so the first thing to do is to say, were the circumstances, were the essential prerequisites for the grant of relief under the Human Rights Act in place in this case on the judge's findings? To which the answer is no, in my submission. So that then begs the question, the Lordship puts, well, is there another justification in this case, nevertheless, for the court to intervene and grant relief on an advisory basis? I would say, if there is, then the case given by the judge, the argument given by the judge in paragraph 50, is one that is difficult to justify because it has no basis in principle in the Strasbourg jurisprudence. In other words, the logic of the Strasbourg decisions, as he puts it, and analysis in those cases, does not, as we've seen, lead to the conclusion that it is the role of the court to give such remedies as ensures that the positive operational duty is being complied with. Far from it. The role of the court is subsidiary, as we saw from Fadieva. So, not justified under the Human Rights Act, not justified on the principles, Strasbourg principles, and the judge, with respect, seems to have got that wrong. One's getting quite a narrow residual basis. And then one asks, well, what is the purpose here of granting the advisory declaration in circumstances where the stated position of the regulator, to whom that advice is presumably primarily targeted, is saying our position is that we are guided by the guidance and the recommendation of Public Health England, and this guidance has come to us too late to be able to say what our reaction to it is. We've said that we will react and we will review, and through counsel we say that we will react and review this guidance. Whatever this court says, that's what we'll do. What then is the purpose for an advisory declaration?
Well, it's as my lord said, if this was the only way, not a way, of complying with Article 2 on the facts of this case was the PHE guidance, one could see a declaration say, well, we haven't got to that date yet because it's January 2022. But if the only way, if it was necessary to do this by a certain date, rather than grant a mandatory injunction saying you must implement the standards by the 31st of December 2021, they could declare that it was your duty to do so. If that wasn't appropriate machinery, it would be spelling out the scope of the duty.
And it might be said that it would avoid any future doubt as to the minimum, if you like, that needed to be achieved. Yes, if that were so, you have my submissions that wasn't the case. There is. I was asked if the judge had dealt with paragraph 133 of Fadieva. Yeah. And in fact, Mr. Hart pointed out to me that in paragraph...
well, he deals with it in 60.
He does. He does mention paragraph 133 in paragraph 39 as well. So I ought just to show you that. It's at page 110. You'll see, there's a sentence about...
yes, it does. It comes, in a sense, out of sequence, but there are several references to 132, and there's a specific reference to 133.
Yeah.
And then he goes on to other paragraphs preceding that.
And then there's a sentence where he paraphrases 133. 1, 2, 3.
It's towards the top of page 110.
Yeah, so 9 lines down. He does a paraphrase of
in my submission, I am able to maintain the point that he doesn't grapple with the true significance of that paragraph and the no information point. The significance of that as the basis upon which the Strasbourg court in that case felt justified in accordance with principle in intervening at the Article 8. The Article 8.
Because his summary of Fadieva doesn't suggest that at the point when he was summarising that case, he thought that para 133 was the most important thing in Fadieva. No. And yet it's the basis of his decision.
No, I mean that critical point. You have the first. You have in the proportionality balance. You have those 2 points. Firstly, the failure to make alternative accommodation available, not of any great assistance to this case. The second and critical point, the adequacy of the government agency's response to regulation of the dangerous industry. That's critical. you get no sense of the criticality of that,
No.
and of the court's reasons for finding that element of the balance had been drawn in such a way as to enable it to intervene. The margin of appreciation having not been engaged with, as it were. Can I then please, if I may, turn to deal with ground 2? We've touched on it already. It's in the skeleton at paragraphs 52.
And actually, sorry, just to get back to paragraph 60, where he quotes paragraph 133 if that is. He characterises that passage as the breach of the positive operational obligation was because, and there is no vision. The point about information isn't what the court said was the breach.
No.
The fact that there was no information simply was the court saying, well, there's nothing to contradict the case that there's a breach.
There's nothing, because there's no information,
Yeah.
it's the state, we have to infer adversely that the state has simply failed to grapple with the balance. And certainly the breach, to say it was because the polluting enterprise at issue operated in breach of domestic environmental standards is not correct. It was the fact that the polluting enterprise operated in breach of domestic environmental standards that was a key driver to Article 8 being applicable.
Yeah.
Well, the breach is explained in 132, and as my lady says, 1.3 says, and there's nothing to contradict the reasons for finding the breach in one. If you look at 132, fair day over first. I think that's my lady's point. They put the thing in the middle of a town.
Yeah.
It's above the legislative limits. They've established a cordon sanitaire that they don't enforce.
Yeah.
And that's what gives rise to the breach. And there's nothing to explain what they're doing to sort it out. But it's not they exceeded domestic standards and they haven't given information, therefore there's a breach. You can't have 133 without 132.
No. But, and I just make sure I haven't.
What the state finds is in 132. And it goes on to say you can't say they've got to give her free housing to get her out of the area where the thing is. And in any event, it's not for the court to say what the precise measures should be. But here, there was a need for special treatment. It didn't offer any effective solution. And there was no explanation as to why they were acting in the way that they did. That's what 132 and 133 say, actually. My lady says it's not quite what, or on one analysis, it's not quite what the judge says. It says it's 60.
No. But you surely the safe analysis is to read 132 and 133 together. They are the two paragraphs which sum up the court's reasoning for finding a violation of Article 8. In other words, they sum up what it is that leads to the conclusion in 134. Ground 2 is set out on in our skeleton on page 13, paragraph 33. the principal argument are the first two sentences of paragraph 33. The judge erred in making a declaration in circumstances where there was no finding of the party's current breach of positive obligation by the appellant. There was therefore neither a justification nor a requirement for a remedy. It wasn't. That's the submission of principle, if you will. Then, as we've seen, it didn't form part of the relief which was sought actively by the respondent. A declaration as to what the agency needed to do in future, then there are concerns and submissions made about the content of the declaration. I can deal with those. We deal with those points. I'll come back to the question of principle and develop that in a little. But insofar as those further points are concerned, they essentially are the second and the third submissions that we set out in paragraphs 55 to 60 and 61 to 63 of the skeleton argument, respectively. And they are founded on the submission that if it was in principle justifiable to make a declaration in this case, then the declaration should have gone no further than to identify the objective to which the agency should be devoting its regulatory activities. That is to say, that it should be devoted towards measures that were designed to achieve or to fulfill the recommendations of Public Health England. But to say, for example, that will and do achieve is going too far, because that imposes a legal straitjacket that is, firstly, which ousts the agency's regulatory function and its task of making its own judgment about matters. And secondly, it risks imposing upon the agency an obligation to achieve a specified legal result without evidence before the court as to the degree to which it was actually at risk of being achievable, notwithstanding the best efforts of the agency. And it is hardly consistent with good administration for the court to set up a standard which a regulatory body is required as a matter of law to achieve without having satisfied itself that that standard is able to be achieved with a degree of certainty that admits of no realistic doubt. So if there was to be a declaration, and if there is to be a declaration, contrary to our principal submissions, then the declaration should be in terms which simply identify and advise that the agency should be designing measures which seek to achieve the acceptable levels recommended by Public Health England, and no further than that. And
I'm just pausing, I'm sorry to interrupt you. Has that been formulated?
I haven't formulated it yet, no. I can formulate it for you before.
I mean, it might actually help to sharpen the focus on what this submission means. I mean, this is clearly in the alternative to your primary.
Yes. Yeah.
Your primary argument is that there should not have been a declaration. This is in case we are against you on that argument, but nevertheless conclude that the judge's declaration was inappropriate in its terms.
Yes.
So, without attempting to be precise necessarily now, can you just give us the gist of what would, as it were, without prejudice to your main argument, have been an appropriate formulation?
Yes. If one looks at page 81, which is the actual declaration, it may be helpful to try, just to give you an idea of, give you my what my submission was is and this is founded on what we say in the skeleton argument.
Yeah.
The words in the fifth line, and do, those words would need to be removed. As I've said, that otherwise the declaration crystallizes into legal obligation, the agency guaranteeing the achievement of an outcome. So one would, the declaration would read, in order for the environmental agency to comply with its legal obligations, the agency must implement the advice of Public Health England, as I expressed, by designing such measures as in the agency's regulatory judgment are predicted to achieve the following outcomes. The use of the word predicted is appropriate here because it recognises that this is a forward-looking exercise which involves inescapable uncertainties of environmental factors and scientific judgment.
Yes.
And the
so will and do, it's will and do to be replaced by are predicted to.
yes. And the declaration should also, to reflect the concerns we've set out in our should also reflect the fact that the recommendations may change. And it is, although in speaking in August of 2021, Public Health England judged it appropriate to make the recommendations that it did, and to found those recommendations on the guidelines for acceptable levels of gas emission. It is an inescapable possibility that Public Health England's position may change whilst during the operational lifetime of this facility.
Well, they changed between the third and the fourth iteration.
Indeed. And so the declaration would need to say something like, subject to any future variation or amendment to those recommendations. And so that advice, rather, it's couched as advice.
Subject to any future
variation or amendment to that advice.
I think, subject to what my colleagues suggest, I would be minded to give you the opportunity, not now straight away as it were, but overnight, to formulate this for us, so that will assist the other side too in
yes.
any submissions.
Certainly, I would certainly wish to do that. I'm just simply seeking to give you an idea.
Yes, no, it's very helpful now,
yeah.
because that's what I've invited you to do. But if, I think we might find that
You need it tomorrow morning, though.
But we do need it tomorrow morning.
Yes, yes. you can see that, and this may change once we've thought about it overnight, but you can see that already what is intended to be an advisory declaration is beginning to display such a degree of uncertainty, properly needed in order to accommodate the variations and the future, as it were.
But it's not your submission that such a declaration could not be formulated, or is it?
It's not my submission that it could not be formulated, but it is my submission that as one goes down the road of trying to think about how it might be formulated, the less it becomes more obvious that it's not helpful.
Yeah, in fact, you'd want to change the open bit in order for the Environment Agency to be able to demonstrate it's complied with its legal obligations. Your declaration is becoming you'll be all right if you stick to the PHE guidance, so long as nothing else happens.
Yes, but
that's what you're really saying the declaration should be.
Yes,
I think.
And in essence, yes, and I don't, frankly, I'm not going to apologise for that, because that is no more than to expose
the weaknesses in this.
The weaknesses in the analysis. Yeah.
Exactly.
Yeah. It's not intended to be a forensic exercise alone in that way. I mean, as I thought about this, I thought to myself, there was a scenario in which the court might think, well, that was the wrong declaration, but nevertheless, there is a case here for making one, and therefore we ought to give you some help in that. So that's what I'm. But it's,
well, I think it will help us. It will also assist the other side to know precisely what you're saying.
Yeah.
So therefore, we do need to have it the start of play tomorrow.
We'll certainly do that.
Thank you.
But as I say, the principal point under ground 2 is that the court was wrong in principle to grant relief in this case. Can we turn to the Human Rights Act?
Yeah.
Section 6 is very familiar to all of us, but provides that it's unlawful for a public authority to act in a way which is incompatible with a convention right. Subsection 6 tells us that an act includes a failure to act. So it's not only unlawful for a public authority to act in a way which is incompatible with a convention right, it's unlawful for a public authority to omit to act in a way that gives rise to incompatibility with a convention right. Section 7 provides the first part of the effective remedy in relation to such a breach. Subsection 1, a person who claims that a public authority has acted or proposes to act in a way which is made unlawful by section 6.1 may bring proceedings against the authority under this Act in the appropriate court or tribunal, or rely on the convention right or rights concerned in any legal proceedings, but only if he is or would be a victim of the unlawful act. And as we know, commonly such a claim is made in the context of judicial review proceedings. And then section 8 1, in relation to any act or proposed act of a public authority which the court finds is or would be unlawful, it may grant such relief or remedy or make such an order within its powers as it considers just and appropriate. There is a case in the bundle in which Lord Nichols gave some guidance on the approach to Section 7 and 8 of the Human Rights Act. It's the case of S. Which is at tab 12. This is the case involving a care plan in children's care proceedings. And the adequacy of that plan. The passage I draw attention to is, as I understand it, Lord Nichols attempting to elucidate matters of principle in relation to Section 7 and 8 of the Human Rights Act. You find that at page 337 in the bundle, internal page 315. He said at 45, Sections 7 and 8 of the Human Rights Act conferred extended powers on the court. Section 6 makes it unlawful for a public authority to act in a way that is compatible with the Convention right. Section 7 enables victims of conduct made unlawful by Section 6 to bring court proceedings against the public authority in question. Section 8 spells out in wide terms the relief the court may grant in those proceedings. The court may grant such relief or remedy or make such order within its powers as it considers just or appropriate. And then he, at 47, he says, in the present case, the Court of Appeal seems to place some reliance on Section 7 and 8 for the extension of the Court's powers envisaged by the starring system. That is a comment on the approach that the Court of Appeal took to the to managing the care plan in question in this case. Lord Justice Thorpe said, the responsibility on the courts in the exercise of extended or additional powers is, of course, to ensure that they are used only to avoid or prevent the breach of an Article 6 or Article 8 right of one of the parties. If no actual or prospective breach is demonstrated, the power does not arise. I do not think Sections 7 and 8 can be pressed so far as would be necessary if they were to bring the introduction of the starring system within their embrace. Sections 7 and 8 are to be given a generous interpretation as befits their human rights purpose. Despite the cautionary words of both Lord Justice Thorpe and Lady Justice Hale, the starring system goes much further than provide a judicial remedy to victims of actual proposed unlawful conduct by local authorities entrusted with the care of children. Section 7 envisages proceedings brought by a person who is or would be a victim against a public authority which has acted or is proposing to act unlawfully. The question whether the authority has acted unlawfully or is proposing to do so is a matter to be decided in the proceedings. Relief can be given against the authority only in respect of an act or a proposed act of the authority which the court finds is or would be unlawful. For this purpose, an act includes a failure to act. So, yes, a wide and generous interpretation, but the words nevertheless mean what they say. And if one is to, in the present case, it is simply true to say, my submission, that there, on the judge's analysis, there is no finding of an act or failure to act that is unlawful in terms of Section 6 of the Human Rights Act. No violation. And secondly, he does not find that the agency proposed to act or to fail to act in a way that is or would be unlawful. And to be clear about that submission, in order for him to have found that the agency proposed to act or to fail to act in a way that is on its terms and in the light of Lord Nichols' analysis, a necessary prerequisite to the grant of relief under Section 8, he would need to have made a finding that the agency positively intended not to align itself and to review and to act on the recommendations of public health. Because a proposed act necessarily entails some evidence of intent. If you propose to do something, you have it in mind to take that course. And what is absolutely unarguable here in my submission, I put it as highly as that, is that there is nothing in this judgment that supports the response that the judge found the agency intended, had it in mind, not to act, not to respond appropriately to the recommendations of Public Health England in NC4. I've to the contrary from this morning. You know, my submission is that it was far from that. But that is the question, the relevant question, so far as section 6 to 8 of the HRA is concerned.
Yes, but I thought you'd accepted that you still have jurisdiction generally to grant declarations. There are cases, leaving aside the Human Rights Act, where the government department says we are going to act in accordance with a particular convention, like the Trafficking Convention, and the courts can grant declarations, advisory declarations, as to the meaning of that. So I understand your argument that you can't say this is an exercise of power under 7 and 8. Those aren't intended to restrict the circumstances in which declaratory relief, if otherwise appropriate, could be granted.
Well, that brings us back to the point. Was the judge justified, nevertheless, in...
Yes.
Yes. But it is nevertheless, in my submission, of significance.
You say it's the starting point.
Yes.
You're not saying it's a jurisdictional limitation, are you?
I'm saying that it was that it looms large in the argument that the judge lacked the justification, which is not a jurisdictional argument, but it is an argument as to whether the judge ought to have done what he did, and brings us back to what Lord Justice Mayles said in granting permission in this case. The judge has made an unusual order which was not sought by the parties.
Not really helpful, but there is a Court of Appeal case, the name of which escapes me, but the judge was Lord Justice Peter Jackson. It's about paragraph 64. And after the hearing, when somebody was going to make some recommendations or implement some recommendations, and the hearing had not gone well, they wrote to the Court of Appeal and said, we're withdrawing the proposed recommendations, therefore you can't grant a declaration, because we're not proposing to act under Section 8. And they got short shrift and were told if the court had thought it appropriate to make a declaration, they would have, although they didn't actually make one. But it doesn't help that I can't remember the name of the case.
Well, yes.
It was very exciting when I read it.
Well, as your lordship put to me earlier, the facts are important indeed. No, I mean, I'm not...
So you're not saying there's no jurisdiction.
I'm not taking a bright line
no,
point.
you're simply saying that's what it's there for, and if you're going to go outside and do something unorthodox, not connected with Section 7 and 8, there needs to be justification, and there isn't here. That's what you're really saying, I think.
Yes. And we in our written submissions, we have also drawn attention to the Bell and Tavistock decision, which I know I mentioned with some hesitation.
No, do rub salt into the wounds. It's perfectly fine.
I know, that's what I had in mind. Not my intention at all. But there is, again, it's not a... It doesn't refute your lordship's point, because it's not my purpose to do so about the residual power of the court. But it is... Can we just look at it, if you can bear to? I don't think I need to decide.
Dwell on it.
No, but if we, it's at tab 2, page 33. Just remind you, the issues before the Court of Appeal are set out at paragraph 58 to 60. And 59, the only real question before us is whether the Divisional Court, not having held that Tavistocks and the trust policies and practices were unlawful, right to make the declaration and give guidance. I just was going to draw your attention to 67 to 69 under the heading was the divisional court right to have made the declaration. So page 34. Mr Hyam, I think acting for the claimant, submitted that the divisional court was justified in making the declaration, giving guidance even where the claimants failed to make the case on legality, and therefore no coercive order was appropriate. And secondly, the court was concerned with the future. I mean, there is a certain resonance there with what we have in the present case. Mr Hyam relied on a passage from De Smith. In many situations, all that is required is for the legal position to be clearly set out in a declaration for a dispute of considerable public importance to be resolved, and that such declarations are increasingly being used to pronounce upon the legality of a future situation, and in that way, the occurrence of legal action is avoided. Section 9. A declaration may be sought in private law proceedings to resolve a legal dispute. It binds the parties and those privy to the proceedings. In public law proceedings for judicial review, a declaration is a common alternative to coercive relief following a finding that the defendant public authority has or proposes to act unlawfully. That is the effect of the passage from De Smith just quoted. That is the dispute referred to in paragraph 1808. The dispute identified in these proceedings was whether an application to the court was always needed before the prescription of puberty blockers, because no child under the age of 18 could give valid consent. Had the claimant's case succeeded on that issue, declaratory relief would have been granted. So there is there, in this court, some salutary observations about the deployment of the power otherwise than in a context where a finding of unlawful act or omission has been made.
Of course, given the timing, this judgment was not for Mr Justice Fordham.
No.
Nor his before the court.
No.
Before this court in that case.
That is, I think that is right.
Is that right or not? That judgment was handed down on the 17th of September.
Yes. He handed down his on the 16th. Yes. So.
And there's no reference to it, is there, in the
No, I don't think so.
judgment?
No.
And he says flogging a dead horse. It does still say that there are appropriate cases for an advisory declaration under section 31(2), but that was not one of them.
Well, and I say this isn't one of them. I mean, that's essentially the point.
Not so much a dead horse, but one that's been buried for some years. But you know what I mean. Yes.
But the risk of treading on sensitivities. I'm sure I'm not. Was the first instance decision in Bell cited to Mr Justice Fordham?
I don't think it was.
I wouldn't have thought it relevant.
No.
Actually.
No.
This is a sort of a midway, this case actually, because it's tied to breaches and it's looking at the future situation. I suppose you could say that is actually what the misguided divisional court thought they were doing in Bell.
It would be very difficult to see any clear factual correlation between that case and this, obviously, and it would be a waste of everyone's time to try and do it. My reliance on it is, I hope, relatively modest. but I mean,
it's actually hard to think of a case where there has been an advisory declaration. In fact,
yeah,
off the top of one's head.
One of the advantages of the court taking a relatively acting with caution in exercising that jurisdiction is that it means that the court is confining itself essentially, or in very large part, to granting declaratory relief in order to remedy a finding of legal error.
Yeah.
Is that you are able, the legal error defines the scope of the declaratory relief.
Yeah.
And whereas if one is doing something beyond that, one runs immediately into choppy waters.
Yes, we tend to use the words relief and remedy interchangeably, I think. But when one focuses on the word remedy, the question that follows is, for what?
Quite.
And if that question, here's a remedy, it's a declaration, and it's in these terms, That is a remedy for what, would be the question. If one just approached it in not even legal terms, but ordinary everyday terms. Remedy for what?
And if one follows that line of thinking and says, for what was the declaration in this case a remedy? It's difficult to see what in practice it was remediating, given that the agency had spelt out in paragraph 69 that it intended, in a way that was consistent with its function, to do the things that in substance the judge was saying it needed to do. That is to say, it has said that it would take account of and would adjust its regulatory actions in line with and in response to the advice of Public Health England. So if on analysis what the judge was doing was giving clarity to the need for the agency to do that, was that clarity needed, given that he had recorded in his judgment the agency's stated position through leading counsel, and that stated position, in general terms, was entirely consistent with the agency's evidence? I say in general terms because, as we've seen, the agency didn't say specifically, we have this report and we are going to do what it says. But it did say, we are going to keep the actions we are taking in this case under review, amongst other things, in response to guidance. So one might have thought, with respect, that in those circumstances, the judge's judgment would stand as a record, a public record, of what the agency could be held to. And if the agency turned around 2 months later and said, well, actually, we've decided it's all too difficult, or we're not prepared to resource the process of reflecting and reacting to Public Health England's guidance.
If you go back to 64,
Mr.
the first half of the main paragraph is a bit odd in one sense. It gives lots of reasons for giving it and says, granted declaration, just and convenient, provides clarity and reassurance.
Oh, yeah.
Well, why we should be doing that is an interesting question. Critical to make it clear that something must be done, secure and practical and effective human rights. It will require pressing and ongoing action and so on. It'll make a very real difference for the air which Matthew and the community breathe. And then you go on to it, and it does all of that because it's turning the standards into an irrevocable legal obligation that you've got to comply with. But that's what it does. In order to get that, he's not saying this is the law and I'm going to declare it for clarity. He's almost saying we need clarity, so I declare that this will be the law.
Yeah. But again, all of those things assume that the stated position of the agency, which he has accepted in paragraphs 59 and 60, doesn't. I mean, there are countless instances of the courts, both at first instance and at appellate level, saying, in a sense, this judgment will act as an indication of what it is that the relevant state body needs to do. And when that state body has said this is what we are going to do, the point is particularly is reinforced. So that's not a jurisdictional point. It's a case of justification.
Well, we must not forget. It might be submitted. As the judge himself states in the very first sentence of his judgment, and he comes back to Matthew, of course, in the paragraph we've just been looking at, paragraph 64, but in the very first sentence of his judgment in paragraph 1, he states firmly, this case is about a 5.5-year-old boy, Matthew.
Yes.
His community in the Staffordshire former mining village of Silverdale and the Walleys Quarry landfill site. So the judge is, from the outset, reminding himself and everyone who reads the judgment what this case is about. And that is echoed, it might be said, when he brings his mind ultimately to the outcome, the heading of paragraph 64, and what he should do about it, as he perceives it to be.
Yeah.
And that's the frame, if you like, in which he's granting this relief. Now, it's right, I think, Mr. Mould, that the court should give you the opportunity now to consider whether the judge's approach, as it were, framing the case in the way he does, in that very personal way, makes any difference to the submissions you've made, or no difference at all.
It makes no difference to the submissions I make about the justification for intervention. And I say that, I hasten to add, that is in no way intended to deflect from the very real sensitivity and the vulnerability that the judge has found in the case of Matthew, which we, as I say, we in no way seek to quarrel with. But in responding in that way to the Lord's question, I have in mind what the judge went on to say in paragraph 1, where he says, in legal terms, the case is about whether the EA is discharging its statutory duty, etc. So having identified the undoubted and very serious factual sensitivities of the case, he goes on quite rightly, straight away, to say, this is a court of law, and my task is to consider the legal issues raised by the case, which are to do with whether the Environment Agency is discharged its duty.
We've got to look at the last part there, because it says in the light of all that, the two critical questions are whether positive operational duties are triggered, and the content, and what he's trying to do is describe the content.
First, and as regards the triggering, that essentially was common ground.
Yeah.
As regards the content, that has to be resolved by reference, on the basis of principle.
Yeah.
The fact that the case is a sensitive one, and undoubtedly so, doesn't provide any support to departing from principle. And the margin of appreciation applies as much to a case involving, in this case, a vulnerable 5-year-old boy, as it applied to people living at risk of having of being obliterated by a landslide in Budiyeva. Someone who had been subjected for years to a cocktail of poisonous gases in Budiyeva. A man who had been encouraged by the state to put his family on a landfill that exploded in Turkey. Or releasing a psychiatric patient on home release when that, without negligently, in circumstances where it was obvious that person was at risk of suicide in Rabone. These are all highly sensitive cases.
Well, I think in Rabone, I think Lord Dyson observed that, I think I recall the observation that it was irrational to allow Melanie Rabone to go home in the circumstances in which she found herself.
Yes, it was beyond the range of reasonable responses.
I think he said that.
Yeah, I mean, Rabone was a bold case to defend, really. When you think when there had been an admission of negligence, and yet there was a defence to the existence of a positive operational duty in circumstances where there had been an admission that it had been negligent to allow this patient to go on a it was certainly a striking set of facts, and I think one sees a sense of the judge's surprise about that in paragraphs 42 and 43 when he deals with Miss Carter's submissions about breach. It would be wrong to suggest that this case is somehow on the mild end of the spectrum. This is a case where undoubtedly during the course of this year both Matthew and the community in which he has lived have had to put up with very serious environmental harm and disadvantage.
They clearly have.
Yes, indeed, and it is that fact that brings the operational duty very firmly into focus. The agency can't cure everything, but it clearly has a duty, and that duty is been the subject of careful consideration by all parties in this case. It doesn't follow that this case is so exceptional that, if you like, it goes beyond the circumstances that the European Court had to grapple with in the cases we've looked at. And we can see that in those cases, the focus has been on the adequacy of the state's response, viewed against established principles. Under Article 2, essentially, the reasonableness of the steps taken. Article 8, the focus has tended to the resolution of the issue of violation has tended to focus on the question whether the state has operated, has taken a sufficiently active and careful series of steps and measures in response to justify the conclusion that its response falls within its margin of appreciation. And I say that is this case.
Right. Thank you.
I've gone longer than I thought I would, but
well, we've asked you a number of questions to clarify things as we've gone along.
Yeah, I'm great. Unless there's anything else.
No, thank you very much. I've asked both my colleagues whether they have questions, and none of us do. Thank you. Thank you very much, Mr. Moore.
Thank you.
Yes, Mr. Wise.
My lords and my lady, my Lord Justice Limbaugh asked my lady friend a few moments ago about his response to the position of my client, and it's that to which, unsurprisingly, I wish to turn to first. It also comes out in the context of the discussion that the court had just after the short adjournment about the directions and the dynamics of this case and what brought the case before the court in the first place. You will have seen from the papers, or hopefully will have seen, that this child, Matthew, was reported on by Dr. Sinner on the 4th of July. We have that in the papers, if I can take the court to it, at page 70 of the supplementary bundle. I don't propose to take the court all the way through, just the headline points, and you'll see from the first page that the doctor, who, as we see, is a consultant respiratory paediatrician and honorary clinical professor at Alderhay Children's Hospital near Liverpool, and he summarises his opinion on the first page, and the court will see that what he found, having seen the notes and consulted with this child and his mother. Environmental exposure to hydrogen sulphide is significantly impairing Matthew's current health and quality of life. Continued exposure will have a lifelong detrimental effect on his future respiratory health, and this will subsequently reduce his life expectancy. He goes on and he puts this in capitals and underlines. Matthew and other residents of Silverdale are living through a public health emergency with potentially catastrophic consequences. Pausing there, there's been some discussion during the course of today about the extreme circumstances of the cases considered by the European Court. It could well be said that this case is of a very similar magnitude. discussing here potentially catastrophic consequences. And then at 3 we see the levels of hydrogen sulphide from Walleys landfill site are high enough to cause airway and lung problems in Matthew and his community. Chronic exposure to hydrogen sulphide poses particular risk to vulnerable people, including the elderly, people with respiratory illness, and the 1,773 children under the age of 5 living in the area immediately adjacent to Walleys landfill site. In my opinion, based on current research evidence, exposure to environmental hydrogen sulphide is presenting a direct and indirect threat to life for Matthew and other vulnerable residents in Silverdale. Now, it's not surprising that in the light of a report as stark as that, the proceedings were issued very quickly. A letter for claim was sent, as one would imagine. I think it was within a fortnight the proceedings were issued, and we did seek urgent consideration, and there's been no issue taken as to whether we should. No issue could possibly be taken with respect to that. Now, at the time, of course, we didn't have the full background information, and what's immediately apparent from rereading the papers in preparation for this appeal is how quickly this case evolved from the beginning of July until the middle of August when we got into court. When one looks at the skeleton arguments, for example, in the court below, we can see that they, even at that stage, a week before the hearing, things were still crystallising and moved on considerably by the time of the judgment. And it was the judge himself who relied on the importance of the Public Health England reports. Our claim was essentially based on Dr. Sinner's report and our submission that in the light of that report, there was a breach of Articles 2 and 8 at that time in substance with respect to this child. We'll turn presently to see how the judge dealt with the legal issues. But what's of crucial importance, and of course the Maloney Friends appeal, the Environmental Agency's appeal, is about the nature of the relief in this case. It's not about any particular findings that the judge made. And one always has to bear in mind, of course, that relief is a discretionary remedy. And it's a high hurdle for an appellant to achieve, to displace a discretionary remedy when in effect there's no challenge to the findings along the way that led to the judge granting the declaration that he did. But that being said, if we can turn to the way in which the judge considered the evidence with respect to Matthew, I'm going to take the court to the judgment itself, and we see where the judge sets out at paragraph 24, 15 of the report, what Dr. Sinner's assessment of Matthew was, bearing in mind, of course, that the judge heard from Dr. Sinner, heard live evidence from Dr. Sinner, and so was in a good position to consider the veracity of his evidence. We'll see halfway down paragraph 24 on page 15 of the report that Dr. Sinner had told him that in the scheme of things, Matthew's current condition would make Matthew the worst case in clinic, and emphasised, which he emphasised, that's worst case in clinic in his respiratory clinic at Aldale Hospital. And then he goes on a few lines further down that Dr. Sinner told me that he agrees with the assessment of Dr. Samuels, himself a renowned consultant paediatrician. If we can just turn to that, because that's an important milestone along the way. We've got that, I think, in the core bundle, page 123. Sorry, it might be the supplementary. Sorry, I apologise. It's a supplementary bundle. In the supplementary bundle, page 107, 123, exhibited to Mrs Curry's first witness statement.
Yeah.
Where the court will see that this is a letter from the consultant to the GP, dated
26th of April, dated.
Put my glasses down.
He was seen in a clinic on the 23rd. Top left-hand corner of the letter.
Yes, that's right. Diagnosis: aggravation by environmental toxic gases. You see in the diagnoses, my lord. But also towards the bottom of the script, Matthew seems to be clearly suffering from the environmental fumes he is subjected to on a regular basis, given they live so close to the landfill, etc. So that was Dr. Martin Samuels, who is referred to in the judgment at paragraph 24. And Dr. Sinner then goes on, 5 lines from the bottom of that page. Dr. Sinner's opinion expressed in his first report and maintained includes the following. The environmental exposure to hydrogen sulphide at the current levels is significantly impairing Matthew's current health and quality of life. That continued exposure will have a lifelong detrimental effect on his future respiratory health, and that this will subsequently reduce his life expectancy. And then over the page, if I may, my lords and my lady, importantly as I saw it, this assessment by Dr. Sinner was not premised on his zero tolerance opinion, rather it was focused on current levels of exposure to hydrogen sulphide from Walleys Quarry. So that was how he presented the evidence. If we can then go to paragraph 54. And what we see, if we pick it up at the end of that paragraph on page 43 of the report, in any event, I am satisfied that Dr. Sinner, in his evidence in this case, was describing a reduced life expectancy which is both substantial and significant.
Sorry, you pitch paragraph 54?
Sorry, paragraph 43. Yes, paragraph 54, page 43, my lord. His lordship had me. Last 3 lines of the paragraph.
Yeah.
Oh yes, sorry, yes, I see that now, yes. I'm so sorry.
In any event, I am satisfied that Dr. Sinner, in his evidence in this case, was describing a reduced life expectancy which is both substantial and significant if Matthew were to develop COPD, which evidence I accept. So the judge accepted the evidence, no appeal against that. If we can just go on a couple of pages, paragraph 56. Discussing the Brincat case and whether there was a real and immediate risk to Matthew's life. If we can pick this up towards the bottom of the page, that means, if we can pick it up there, Matthew's BPD is not attributable to the hydrogen sulphide emissions but rather to his premature birth. It was the submission. That means there's no parallel with the situation being considered in Brincat in this respect. Number 3, however, on the evidence of Dr. Sinner, 1, there is a pathway from BPD to COPD which is inexorable unless Matthew recovers. 2, Matthew is not recovering. And 3, Matthew's non-recovery is attributable to current levels of hydrogen sulphide exposure from Walleys Quarry landfill site. Very important findings in our submission. And it's very important to emphasise that. But the judge found that his non-recovery is attributable to current levels of hydrogen sulphide exposure from the quarry. And so what we then have to turn to consider is what those current levels in fact were. And the judge records at paragraph 32 of the judgment.
32.
32, 32.
Yeah.
It's a long paragraph. Page 21 of the report. is in the 4th sub-paragraph dealing with 2001 emissions were above the WHO half-hour guidelines of 5 parts per billion. You'll see there he sets out the times where those guidelines were exceeded. Now we have that in, and you'll see that that was 9%, 12%, 6% and 31% at the varying monitoring stations. And then he also records, if we pick it up towards the bottom of that paragraph, that describing these outcomes, Public Health England's conclusion was, at page 9, the results for hydrogen sulphide continue to be above the WHO odour annoyance guideline value for a considerable percentage of the time, which is undesirable due to the effects on people's well-being and the symptoms they are experiencing. So that was the
I got the sense that you're telling me, if I've got the wrong sense, that when you're talking about the WHO half-hour guideline, quite separately from the question of the long-term exposure,
yes,
that it was more an Article 8 issue. It was odour and the annoyance and some medical symptoms that you can get, eye irritation and so on.
Well, I take your Lordship's point about that, but the simple fact is that Dr. Sinner's report said that it was the current levels that were causing the threat to his life expectancy.
Yes, but there were two sources of that. One was the exceedance of the half-hour interval, and the other was the levels more than 1 particle per billion. And it is, I think, helpful for us to know whether you're saying that the breach of the WHO half-hour guidelines, whether your case is that that gave rise to the breach of Article 2, or whether it was only the breach of the EPA, whatever it's called, the 1 particle per billion.
Your Lordship says that there are two sources of...
two sources of guidance, not two sources of hydrogen sulphide.
Two measurements. Two
measurements, yes.
Absolutely. But the point is that Dr. Sinner found that the current levels, and the judge found that the current levels were reducing this child's life expectancy.
So are you saying that even if they met the long-term, more than 364 days of exposure to the levels would lead to health things, even the half-hour, even if they were exposed to the particular MF mobile measuring station, that breach of the guideline, irrespective of the other one, would be a breach of Article 2 as well, not just Article 8. I just need to know what your case is, that's all.
I understand the case entirely, because the symptoms of the what's called odour and nuisance, it's more than odour and nuisance, of course. We see that in the papers. This isn't just a bad smell by any means, but nevertheless not such that one would expect it to be causing a risk to life, and that's obviously your Lordship's point. Well,
that's what I want. It's not my point. I want to know what your case is. Are you saying the WHO half-hour guidelines would not lead to a breach of Article 2, but they would lead to a breach of Article 8, or are you saying
on its own, certainly, my lord, that must be correct.
So right.
But Dr. Sinner wasn't concerned with those measurements. He was concerned with the impact of hydrogen sulphide generally.
I understand that. That's why I'm asking about your case now, when we've got the evidence. So you've just told me, I've written down that the WHO half-hour guidelines will not lead to a breach of Article 2 on its own. So is your case that it is the combination of the WHO and the EPA? Because the point is, if they sort one out, say they sort out this EPA thing, you'd still have a problem with the WHO guidelines. So I just need to know whether you're saying it's the combination of the two, the WHO and EPA.
Well, there will certainly still be a problem, and as your Lordship said a few moments ago, at very least, a breach of the WHO guidelines, WHO guidelines, would equate to certainly an interference with the Article 8 rights, and we would say a breach of the same. But in reality, in the real world, those two measurements are inextricably linked, inevitably, because if there's a breach of the 5 parts per billion for half an hour for significant periods, there's inevitably going to be a breach of the 1 part per billion per day
You could remedy the one,
USEPA
but not the
guideline.
other, you see.
Sorry, my lord.
You could remedy the one, but not the other, and there are different breaches at different parts of the site. I'm just trying to understand what you're saying. I think I understand now that the breach of the guidelines, the WHO guidelines, would not lead to Article 2 on its own, but it would lead to Article 8. That's what I've understood your case to be
Yes.
at the moment. And
Yes.
the EPA leads to Article 2 on its own, or reinforced by Article by WHO. Is that it?
Yes, cumulatively, my lord, certainly. That must be the case if one thinks of it logically.
So
you've
EPA
got
plus WHO is a breach of Article 2. What about EPA on its own? I mean, like my Lord Justice Lewis, I'm just trying to understand what your case is.
EPA on its own would be 2 and 8, my lady.
Right.
Okay.
But it's the current levels that the judge was of course concerned with, and those current levels, as we know, are measured by the monitoring stations, and we've got the monitoring the PHE reports on the results from those monitoring stations in the papers. The focus has been on the fourth report, but of course we must also consider the cumulative reports, because that is very relevant to the actions of the Environment Agency. So we have the first report. These reports are all exhibited to Dr. Kurtz's statement. And we have the first report at starting at page 398 of the supplementary bundle. Unfortunately, these reports aren't dated, but this is the information up to the 31st of March of this year.
31st of March.
Yes, we get that, my lord. If you see on page 398, we have there a summary. Does your lordship have that in the
yes.
just above the top whole page? Penultimate line of the first paragraph. So it's the data from the 4th to the 31st of March. We see over the page an aerial photograph of the site. At that time, there was 2 monitoring stations, MF2 and MMF9. My client lives somewhere towards the top left. We've got another photograph that actually has a marker showing where he lives, but it's in that housing area up there. So you'll see that this is in a residential area. At page 400, you see the values that they were using at that time, including both the World Health Organization 30-minute average, the 5 parts per billion, and the US EPA reference concentration exposure assessment for lifetime exposure, the 1 parts per billion. If we go over the page again to 401, the court will see under the heading 30-minute average that at that time the exceedance of that average for these 2 monitors was 22% and 38%.
Are you saying then that there was a breach of Article 8 as at that date for your client, and are you saying B, there's a breach of Article 2 at that date?
Our case was a breach at the time we issued proceedings, and when
Of which article? I've given you 2 articles. You can choose either or both. Was it a breach of Article 2 or a breach of Article 8, or both?
Well, it only became apparent of the impact on my client by the report by the 4th of July from the report of Dr. Sinner, and one would have to look at the impact at that time on this particular child. But the reason I draw this particularly to the court's attention is because there is a focus on the 4th of the Public Health England reports. But of course, this matter goes back some time. And indeed, this is the first time when the monitoring stations were monitoring. They were only put into place because of the extent of the complaints by the local public. And we know from some of the other documents there was a very severe spike in early March. And the complaints had started on a large scale at around the turn of the year. So it was, obviously it took time for the complaints to filter through and the EA to arrange for the monitoring stations to be put in place. But the reality is that this problem had at that time persisted for some time, and that's why my learned friend took the very realistic view that the 365 days that is referred to, the year, goes back to the beginning of this year.
Yeah.
Because plainly there was so many.
And as at this date, as at this report, does this report tell us that the long-term effects, if you have more than 365 days, because we're still only, you said, I think in March at this stage, 31st of March, does it tell us whether over the first 31 days of this year, or indeed any days of this year, it goes above the long-term risk of exposure?
All we have is what's towards the bottom of page 402, my lord.
That doesn't seem to say
No.
that there was anything above the EPA at this stage.
No. The focus was plainly not on that measurement at that time. And the judge is quite right. The focus on the long term impact.
That doesn't emerge until the fourth.
Doesn't emerge until the fourth.
Yeah.
Your lordship has the point. But what's also important is the conclusion of page 404 of this of the bundle. And we see in the penultimate paragraph on that page, the results for hydrogen sulphide continue to be above the odour threshold. Therefore, PHE recommends that all measures are taken to reduce off-site odours for the landfill site. This is acknowledged that odours can affect an individual's well-being. So that's the first time we see a recommendation from Public Health England that they take that all measures are taken to reduce off-site odours. And pausing there, it is of course a condition of the permit.
Sorry, where does it say all measures?
Does your ladyship have the penultimate paragraph on page 404,
400.
the second line? Does your ladyship have that?
Yeah, thank you.
And all measures in that context means what? Are we told somewhere?
No, we're not told what it means. It just means what it says, my lord.
Yeah, I mean, it doesn't particularise what the measures are.
No. But one wouldn't expect that from Public Health.
No, I'm just simply asking whether it does.
And I was just saying that it's of course a condition of the permit that there isn't off-site odours in any event. But this Public Health England isn't interested in or isn't concerned with the compliance with the permit. It's concerned with the public health implications of the off-site odours and its subsequent impact on, as we see, the well-being of individuals in the vicinity. So that then is the first of the reports. If we can go on a few pages to page 411. We get the second of the report. This is dealing with the period March to April of this year. By that time, we've got another 2 monitors being deployed in the vicinity. And we've got that, and we see that from the aerial photograph at page 412. So then see what the 30-minute average guidelines exceedances are at 414, and we see that they range from 2% through to 36%.
And anything about the long term?
No, not again, not on this report, my lord. No.
So the question at this stage, if we stopped the clock, we wouldn't be worried about Article 2 because we haven't got the EPA, and you've told me that it's EPA that's leading to Article 2, and we'd have to ask, given where this young child lives, and it's an Article 8 complaint, whether or not the degree of exposure was such, whether the things that the Environment Agency was doing in March and April when they got these reports, well, we don't know when they got them, was enough to satisfy their duty under Article 8.
Yes.
That's what we'd have to decide.
Yes, but it could be said, indeed it is said, that that could be the tail wagging the dog, in that it's not the monitoring that determines the obligation, it's the impact on the individual that determines the obligation. So what we don't know is whether at that time the impact of the hydrogen sulphide on Matthew was such as to potentially significantly shorten his life, as Dr. Sinner subsequently found. It's the impact on the child rather than the readings that's key.
Yes.
And so we go to the conclusions of the second of the reports. That starts at page 416. We can pick it up at the bottom of that page, the last two lines. The results for hydrogen sulphide continue to be above the odour threshold. Therefore, PHE recommends, as it did on the last occasion, that all measures are taken to reduce oxide odours from the landfill, as it is acknowledged odours can affect an individual's well-being. So, it's a similar a conclusion to similar effect to what we
You've got to read the
saw.
whole of the conclusion. In the second paragraph of the conclusion, is that for the majority of the monitoring period, it was below various measures which were intended to look specifically at the effect on health. Exposure above these values could potentially cause discomfort and irritation.
Yes.
And so on. But based on the current data to the end of April, we would stress that any risk to long-term physical health is likely to be small, but they can't exclude it completely.
Yes.
And there are short-term health effects, and then you've still got the odour problem.
Yes.
So reading that, are you saying that that demonstrates a breach of Article 2, or just a breach of Article 8?
Certainly not Article 2.
Not
There's no
Article 2 at
evidence
that
there
stage.
for Article 2. Can we move on then to the third of the reports? That starts at page 426. This is March to May of this year. And you'll see in the non-technical summary an ultimate paragraph. The current hydrogen sulphide data up to the end of May show continued exposure to the population around the site. And then if we move on to the readings, get those at page 429, you'll see at this juncture the range is 7% to 36%. So they're not getting any better in terms of these readings. Now the fact that these readings were being persistent led to a change in the recommendation, in the formulation of the recommendation. We get that in the conclusion section of the PHE report, page 433, if I may. Second paragraph, the results for hydrogen sulphide continue to be above the WHO annoyance guideline level for a considerable percentage of the time, which is undesirable due to the effect on people's well-being and symptoms they are experiencing. Therefore, PHE strongly recommends that all measures are taken to reduce off-site odours from the landfill. So it's gone from a recommendation to a strong recommendation. So they're obviously becoming increasingly concerned about the impact that these emissions are having. And this pollution, we talk about hydrogen sulphide emissions, it is of course pollution. And then if we go on to the final one of the
Before we
risk
this
assessment.
one, do we know at what date these reports, the three you've looked at, were provided to?
No, we don't, my lord. And we didn't know at the time, and it was only in post-hearing exchanges that we knew when the fourth risk assessment was provided.
Right.
But we can assume that they're a few weeks after the levels that are being considered.
Because this one does begin, the third one at 433, you haven't shown it to us, but this begins to suggest at the conclusions, the third paragraph, that the data up to the end of May shows exposure to the population of one site above levels acceptable for long-term exposure. It hasn't gone on for 14 to 364 days yet, it looks like, but any current risk is therefore small.
Yes.
But presumably if it does go on, which is the point about the 1st of January date beyond 364 days, then you are into long-term exposure. So is it your case that we can or cannot say that there's a breach of Article 2 at this stage, or is it still Article 8?
Still Article 8.
Still Article 8.
We'd say, my lord.
Yeah, thanks.
So then turning to the fourth Public Health England risk assessment, which is what was focused on by the judge. This takes us up to June. And again, the non-technical summary, we see about 2/3 of the way down page 441. The short-term 24-hour guideline for hydrogen sulphide was exceeded at MMF on 2 days. That was the particular spike on the 7th and 8th of March. And then over the page...
Well, the odd thing then is if you look at the next bit, the hydrogen sulphide data up to the end of June 21 still shows exposure above what's acceptable for the long term, but albeit it's at a slightly lower level, it seems, in June than the period from March to May. So there's some progress, slight progress downwards.
Well, when your lordship says slight progress, of course these matters are variable, and I don't think it's controversial to say that weather conditions affect the
and the summer months may be different, like COVID.
Yeah, and in fact the evidence is, and I think the judge touches on this, is that in the winter, colder weather, the hydrogen sulphide can persist for I think it's up to 42 times as long as it is in summer weather, good weather. So there can be a very considerable variance, so, which is why it's important to have the figures
over the 364 days.
Absolutely, my lord. Looking then at the 5-part pavilion level and what PHE said at this juncture, page 442. Looking at 5 lines down, the concentrations of hydrogen sulphide continue to be above the WHO annoyance guideline for a considerable percentage of time, which is undesirable due to effects on people's well-being and symptoms they are experiencing. Similar rubric to that we saw before. And again says and repeats that it strongly recommends that all measures are taken to reduce the off-site odours from the landfill site. So, when we look across these 4 reports as a whole, we see that the Public Health England was plainly becoming increasingly concerned about the impact of emissions, of pollution emissions from this site. And we see over the page at 444 why that's so, or why it continued to be very concerned, is because at that juncture, by the 4th risk assessment, the levels were in the range of 6 to 31%. Now that is of a similar order to the readings that we've seen in the earlier reports. And then we see the strong recommendation again at the bottom of page 444. What's important is we can pick it up at a number of junctures, but since we have it to hand, we'll see here just below the figures, odours can become a nuisance and start to affect people, causing temporary symptoms including headache, nausea, dizziness, watery eyes, stuffy nose, irritated throat, cough or wheeze, particularly if the person has a pre-existing respiratory condition, sleep problems and stress. Now that's important because as the judge made clear, the impact on the community as a whole was relevant to both the Article 8 and Article 2 analysis of this case. And what the judge did was to summarise the evidence of a woman called Mrs. Sian Rooney. We got her statement in the papers, but that's summarised paragraphs 17 and 18 of the judgment, pages 11 and 12. And you can see at paragraph 17, he sets out what, sorry, I'll perhaps take it from 16, where he describes Sian Rooney's report. She compiled what's called the Community Health Service Health Survey report to explore the impact of gas from the landfill site on the physical and mental health and well-being of those living, working in the area. It described what she'd done. Judge accepted that this was evidence of the lived experience of members of the local community. And then at paragraph 17, he sets out a number of what he says are typical statements made in response to the survey relating to children. And can I invite the court to read that paragraph? And then, if I may, also invite the court to read the following paragraph, paragraph 18, which deals with typical statements from and about adults. Now, if we look at the genesis of that report, we get that from Mrs. Rooney's statement itself, which we've got in the papers starting at page 456 of the supplementary bundle. And we see from the first paragraph that Mrs. Rooney lives in the Westlands area of Newcastle-under-Lyme, Staffordshire, 0.9 miles from the quarry as the crow flies. And she goes on paragraph 2 to explain her background: pharmacy technician, registered with the General Pharmaceutical Council. And the court has that. She used to be a service manager at the local hospital with a team of 90 staff. And she lives with a husband and a 3-year-old child. And then she goes on in the subsequent paragraphs to explain the impact of the hydrogen sulphide emissions on her and her family. We just pick up one or two points, if I may. If we can look at page 458.
Well, it's important to note, she starts at 48, she began to notice the smell in February, and then things got bad very quickly.
Yes. Yeah.
And 458?
458, picking it up 5 lines from the bottom, paragraph 4. We've stopped walking and going to the park locally because the smell is very strong outside. I can't enjoy taking a young child to the park if the air he breathes there is poisoned. Similarly, we've not been able to use our garden freely this year. We don't spend time in the garden when the smell is strong. And then paragraph 5, on our days off we take our son out of the area to give him as much fresh air as we can, and we decided with great regret to leave the area. even though we were very happy here and hope to bring Harrison up as a son up here, in the area where I grew up and have strong links. He then says, we have put our house on the market and it is sold subject to condition. So it's that bad that this lady and her family put the house on the market and, as you see, sold subject to condition. And then paragraph 6, you can pick it up on page 459.
We know when, and the problem is, I know this sounds very nitpicking given what the people are suffering there, but it would be quite helpful to have dates, because the claim is that at particular dates things involved a breach by the Environmental Agency, and the statement is dated the 10th of August, and we know that she started smelling it in February.
Yes.
And we just don't have a sense of when it got so bad she put it on the market. Was it March, April, May, June, July? We just don't know, do we?
Don't know. We can find out.
No, we don't want. If we don't know, we don't know.
But we know it's somewhere, obviously somewhere between February
and August, yes.
February and August. The point is how bad the impact was.
They conceded that.
On her. And then if we look at paragraph 6, the second part of which is on page 459, picking it up 4 lines down, I now feel absolutely desperate. I feel that I cannot carry on like this. I can't believe that I'm having to sell my home in order to move to somewhere the air is clean enough for me and my son to breathe safely. I don't know what damage has already been done. So that's the impact on the community. We were looking at the 4th of the PHE report. If we can go back to that, we were on page 444 where we've got the readings from the monitoring stations. And again, the strong recommendation. But as the judge noted, in the conclusions we get we now get 2 recommendations. And the conclusions at page 449, dealing with the WHO half-hour levels, at first in the second paragraph, excuse me, the results of hydrogen sulphide continue to be above the WHO odour annoyance guidelines value for a considerable percentage of the time, which is undesirable, etc. And then, if we go 2 paragraphs down, the hydrogen sulphide data up to the end of June 21 shows continuing exposure to the population around the site above levels acceptable for long-term lifetime exposure. So we now have a particular focus on that metric as well. And as we see, that is of course 14 to 306, the intermediate level 14 to 364 days, so it's beyond the 364. And then overall, the very last paragraph, overall PHE strongly recommends that all measures are taken. If we can insert a 1 there, firstly, to reduce the off-site odours from the landfill site as early as possible. So that plainly WHO half-hour 5 parts per billion guidelines. And 2, if we can insert a 2 after the and, reduce the concentrations in the local area to levels below those health-based guidance values used to assess long-term exposure. And that's why, and that's what the judge described as the 2 strong recommendations from the from PHE. So they strongly recommend that all measures are taken to reduce levels below those.
So is this the date at which you say that Article 2 as well as Article 8 was breached?
Absolutely.
So the date of this.
Well, that's the 5th of August.
Yeah, that's the 5th.
So we go back before that, my lord. We go back to
Article 2,
to the 5th of July with Dr. Sinner's report. This is merely a risk assessment.
Right. So the 4th of July, 21, Dr. Sinner's report. You say there was a breach. Okay.
Yes.
Sorry, I'm looking for the date. I can't find it.
There isn't a date, unfortunately, on it, my lord. That's
No.
the point we were relying on earlier, and that's
It's from a witness statement of courtesy, I think.
It became clear it was the 5th of August.
5th of August, right. And again, if I could just ask, but I think I know the answer, the reference to all measures is again unparticularised in this document.
Yes.
So Article 8, you can go back, you say, to the first report, NC1. Article 2, you can go back at least to the 4th of July 21, when you had Dr. Sinner's report.
Yes.
And in any event, you say it's confirmed in spades by the 5th of August, because
Yes.
you've got the PHE one as well as Dr. Sinner's report.
But the claim, of course, was that at the time of the issuing of proceedings, there was a breach.
Yes.
We haven't fixed a date in the past when the convention right.
No, but your respondent's notice says that there was a breach.
At the time of the hearing, certainly.
Yes.
Yes.
Well, I think you probably mean also at the time that you issued the claim on the 15th of July.
Well, that must be the case.
It must be the case. I think you're saying that in Article 2 terms, no later than the 4th of July there was a breach, and in Article 8 terms, certainly no later than the 4th of July and possibly earlier.
Yes.
Is what I understand.
Yes, well, I think that's a fair characterisation, my lord. Yes. And of course, when we issued the proceedings, we had the Senate, but we didn't have the PHE reports, and that was why, during the hearing, the hearing took a rather different character. I make no complaint about that at all. It was unquestionably a very fast-moving situation. As we observed, as we saw just after the adjournment, we'd originally sought an interim order. The judge declined to deal with that, for frankly, with hindsight, sensible reasons, because it would have taken us long in court time and resources to have dealt with an interim hearing as it would have done the substantive hearing. So when things became more focused, it was plainly the right thing to do, and we had no difficulty with that. As it happened, in order to get ready for the hearing in the middle of August was an extremely challenging timetable for all parties. So if there had been an early hearing, it perhaps wouldn't have been as satisfactory in any event. And so the first ground of the appellant's appeal is, of course, that the declaration granted was not justified or appropriate in the circumstances of the present case. And the most important circumstance in the present case is the information that, with regards to my client's condition, who's in the continued level of current exposure was threatening to was potentially threatening to was a threat to his life expectancy. That was due to the BPED not recovering from the BPED, thereby giving rise to an inexorable, I think is the way Dr. Sinner put it, inexorably to COPD, which would significantly shorten his life. And there's a bell graph in the papers that shows that could be by as much as 20 years. Very significant. And what we say, I noticed the time, but what we say in short with respect to this declaration was the declaration was made for good reasons that the judge set out. It was within his, he had the jurisdiction to make such a declaration, and as I understand it, my learned friend doesn't pursue the point that there was no jurisdiction to make a declaration in these circumstances. His view, as we see from paragraph 64 of the judgment, was that it was just and convenient and in the interest of justice. The rubric in section 8.2 of the Human Rights Act to make that declaration. And the judges, and given that it was within the discretionary powers to make such a judgment, we say that it's very difficult, if possible, to criticise him for that, especially given that there's no error of law along the way that underpins the judgment of the court. And we also say that my learned friend is wrong to say that the judge failed to provide appropriate respect to the Environment Agency, to use the old word deference, I'm rather reluctant to use that word, but respect, I think, is probably respect to the specialist skills and nature of the Environment Agency, by making the declaration that he did. But of course, that's wholly wrong, because when one looks at what the judge actually did, he was well aware of the need for the courts to respect the specialist role of regulatory bodies such as the Environment Agency. He makes that clear in the body of his judgment, and he makes it clear in the declaration itself. And of course, if we go to the declaration, and just for convenience, we'll look at it it's only slightly different, look at it in the judgment. You'll see he refers, I've got it at paragraph 64 of the judgment. He refers, by designing and applying and continues to design and apply such measures as in the agency's regulatory judgment will and do effectively achieve, etc. So the judge very much aware of the role of this court, or the High Court, in regulatory matters. And that's doubly apparent when one looks at the body of the report. If we can go to paragraph 51, about 2/3 of the way down, page 40, just over halfway down. In response, Mr Mole QC submitted that these expressions of all means at its disposal and everything within the authority's power do not serve to eliminate the importance of latitude, at least in a case like the present. I agree with Mr Mole QC, as the judge says. The latitude for judgment and appreciation on the part of the public authorities charged with licensing and supervisory functions in relation to dangerous industrial activity is extremely important, and the judge must never lose sight of it. He had that well in mind, and again he picks it up at paragraph 58. We take the court over to that. This is when he's dealing with step 1, dealing with the positive operational duty. If you can pick it up 6 lines down, from 6 lines into paragraph 58. Mr Mole QC's starting point is that the application of Article 2 and or Article 8 and common law standards must start from the position that the EA as a regulator has latitude involving the exercise of judgments and appreciation in appraising a situation, and B, conducting a sensible inquiry, and C, identifying appropriate steps. That latitude is reflected in the Strasbourg cases through the discussion of the margin of appreciation. The same principal reasons which underpin the Strasbourg court's restraint inform the nature and width of the latitude which the domestic judicial review court should afford to the specialist regulator. So the judge well understood the respect that should be accorded to a specialist regulator. He didn't prescribe what the Environment Agency should do and what measures should be imposed, and he was right not to. What he prescribed was the outcome that they were obliged to meet if they were going to meet their human rights obligations towards my client.
Yeah.
And in doing so, and how to implement the Public Health England's advice and recommendations, which of course, before the judge, the Environment Agency had said that they were going to rely on. Now, along the way, the judge had found that the Environment Agency hadn't made it clear that they were going to implement measures to ensure that the recommendations of the Environment Agency were going to be met. My learned friend said on a number of occasions this morning, and I think after the short adjournment, that what the Environment Agency were going to do was to review the situation in the light of Public Health England's recommendations. That isn't good enough in our submission.
Why not?
Because what that reduces it to, it reduces the duty under the Human Rights Act to protect life and respect family and home life to a power and a best endeavours duty, or a best endeavours duty. Doing their best is simply, we say, not good enough in circumstances particularly when, as we see, my client, this 5-year-old child, is currently, on current levels of emissions, is having his life shortened, and the evidence before the court was that the emission levels weren't getting significantly better. The problem had persisted throughout those 4 risk assessments by Public Health England, and if one looks at the range between the 4 monitoring stations, there's not a great deal between the first and the last, especially when one puts into account the better weather that one would inevitably have in the late spring and early summer, and given what is generally accepted to be the improvement in the situation when the weather's hotter. I see the time.
Yes. Is that a convenient moment to break into your submissions?
We haven't got as far today, unfortunately, as we wanted to.
No.
I don't anticipate being more than an hour at most in the morning.
I mean, how much? There's no criticism of anybody, but how much are we adrift? Do you think?
Half an hour, probably. I was hoping to be an hour into our submissions. I'm some half an hour or so, but we'll still comfortably finish tomorrow.
All right. So there's no.
And I would hope finish by lunchtime.
Mr. Hart wants to have a say.
15 minutes is my prediction for my submission.
Right,
So far,
that's very.
And my learned friend in my reply,
Very helpful.
probably 20. I don't know what my learned friend says, but probably 20 minutes or there.
All right,
So we may well be finished by lunchtime.
So we can start at 10:30. No need for an earlier
I
start.
don't think so, my lord, no.
We should do that.
We'll be okay.
Yeah, I'm not sure we'll finish by lunchtime.
No, but
but
we-
I mean,
we don't need it.
if that's a factor in the court's mind.
No, not especially.
but we'll be finished tomorrow.
Yes, I mean the only thought I'm not only replying. I also-
No.
Of course.
You're
But
dealing
we're
with
being
cost
told
of
that
appeal.
we're just half an hour or so behind
Yes.
schedule.
Yes, I was only checking that because you did mention to me earlier, so we should be done by lunchtime. I was just wondering whether that had an impact on you.
I have to confess, I'm not conscious of any commitments in the afternoon tomorrow, although I may be wrong about that, but that should not be a constraint in itself.
All right. On that basis, I'm not concerned.
So I think we'll start at 10:30 and make as good progress as we can. And there is no pressure, Mr. Wise, on you. Good. Thank you all very much. We shall start again then at 10:30 in the morning. Thank you.